Well, it would give the general reader a window into the world of judges and of how judges go about deciding on the meaning of enacted texts, and maybe most important of all, on what is the true fault line in judges, distinguishing judges. The fault line is not conservative versus liberal. It's rather theories of interpretation which differ greatly from one judge to another, unfortunately.
I'm going to read a long paragraph that you wrote.
Okay, I will like it.
at the end of your preface.
Yeah.
One final personal note, you say.
Yeah, right.
Your judicial author, there's a co-author and you're the judicial author, knows that there are some, and fears there might be many, opinions that he has joined or written over the past 30 years that contradict what is written here, whether because of the demands of stare decisis or because wisdom has come late. Second part, worse still, your judicial author, that's you, does not swear that the opinions that he joins or writes in the future will comply with what is written here, whether because of stare decisis, because wisdom continues to come late, or because a judge must remain open to persuasion by counsel. And then you finish this by saying, yet the prospect of gotchas for past and future inconsistencies holds no fear.
Yeah, I thought that was pretty clever, didn't you?
Well, I thought it was food for questions.
I worry about people pointing out, leaping up to say, well, you say thus and so, and in your opinion, 22 years ago, you say, I didn't review all of my opinions to be very sure that every one of them comports with the truth set forth here, and I didn't want to have to do that. And for the future, any judge has to be open to persuasion, to acknowledge his past ignorance if necessary. So I won't swear that I'll follow this in the future, but I probably will.
Gotchas.
Gotchas.
Who delivers to you gotchas in your life?
Apart from my wife?
Yes.
I would expect gotchas to come principally from academia. Many in academia, probably most of academia does not agree with the theory of interpretation set forth in this book.
Why?
Why? Because they prefer theories that augment the power of the judge, and hence the power of the law professor. The theory of interpretation set forth here is a very humbling one. It does not leave a whole lot up to the policy discretion of the judge. In fact, it leaves nothing up to his policy discretion. The name of the game is to give the fairest reading to what the people's representatives have enacted. That's what a judge is supposed to do. Now, that is an uncongenial approach to someone who wants to do good, who wants to use his office as it can be used to do things that he thinks are good for the society. If one has that zeal, one will not like the approach set forth in this book.
In the earlier part, which you have labeled under forward, you have a sentence here I want to ask you about. Every lawyer, every citizen concerned about how the judiciary can rise above politics and produce a government of laws and not of men should find this book invaluable.